Hello, everyone, and welcome to our session on how to comply with the new amendments to Regulation SP. My name is Alyssa Pugh, and I am the GRC Content Manager for Tandem. What this means is I get to spend a lot of time reading guidance and regulations, and then I get to create resources like this session to help people comply and be secure. I've been doing this for just shy of 12 years now, and I am so excited to be here with you today. Just as a quick disclaimer before we get started, this presentation is for information only. It does contain my own opinions and it is proprietary. A few housekeeping items. This session does have audio and video. So if all you can see is the PowerPoint, well, you'll still get the same great information, just not my face. At the end of the session, give us your feedback and you might just win a $50 Amazon gift card or a really cool hat. More on that later. The slides, recording, and certificate of attendance will be sent to you via email after the session. And finally, please interact with us today. Go ahead and use that questions panel and go to webinar. It might be called Q&A. We do have over 600 people registered, so we will get to as many questions as we can. This webinar is hosted by Tandem, an information security governance, risk management, and compliance application by Conetrix. We work specifically with financial institutions to help them manage and improve their cybersecurity and GLBA compliance with our suite of web applications for things like vendor management, incident management, business continuity planning, and more. We've been around since 2008, and we currently provide services to more than 1,700 financial institutions in all 50 states. So that is us. Now I would love to get to know you. I have a couple quick poll questions to kick us off, and we will have a few of these throughout our time together today. So let me go ahead and share the first one. And that is, which of the following best describes your organization? So we've got investment company, investment advisor, broker dealer, other institutions, so transfer agents, banks, credit unions, and then other third party. So if you're a consultant, if you're a regulator, if you're anyone like that, go ahead and choose that option. So we will give people just a few more seconds to respond. And I will say, if you don't fit into any of those categories, it's all good. Just drop a note into the chat and let us know where you're from. All right, I'm going to share those results with you. It looks like a lot of us are investment advisors today, which is great. About 53% said that. Third said other institution, and then 9% said third party. So whoever you are, we are so glad to have you here with us today. And I see a lot of investment advisors. So big shout out to the Investment Advisors Association members with us today. One more poll question for you all, and that is, how many employees work for your organization? So we've got just kind of a range here, 1 to 10, 11 to 50, and so on from there. So I will give you all a few seconds to respond to that. And this just kind of gives us an idea of, again, who all is on the call with us. So when we know who's here, we can kind of tailor our content accordingly. All right, I'm going to close that and share those results. And we've got a little bit more of a bell curve going on here. So most of us are in the 11 to 50 range, then 51 to 200, and then on out from there. So thank you so much for sharing. Again, I am so excited you all are here, and I hope to have something for all of you today. For our agenda today, we are going to kick things off with an overview of the rule. Then most of our time is going to be spent going through the regulatory requirements of the updates to Reg SP. And then we will wrap up at the end with a few resources and bonus content where I will show you how Tandem relates to this whole topic. And again, as we're going through our time together today, please submit your questions. Again, there's a lot of people here with us, so if we can't get to your question now, we will follow up later. All right, let's dive on in, and we're going to start with a quick overview of the rule. And yes, I do have one more poll question, and then I promise I'll slow down for a little bit. But I'm curious to know, how familiar are you with the Regulation SP updates? So our answer options here are very familiar. So Regulation SP is your life right now. Mostly familiar, you've read a few articles and are finding your way around. Somewhat familiar, so you've heard it got updated, and that's really good. And then not at all familiar, and that is why you are here. And I love how honest you guys are being. This is wonderful to see. Okay, I'm going to close that and share those results with you. About 2/3 of us are in the somewhat to not at all familiar grouping. So that is really good. I am glad you all are here. And again, I'm hoping that you are going to be a lot more familiar with Regulation SP by the time our session is done today. So what we are looking at today is the SEC's recent update to Regulation SP on privacy of consumer financial information and safeguarding customer information. That's a mouthful. So we are just going to be calling it Reg SP today. So when I say that, this is what we're referring to. This update has been in the works for a while. It was first proposed in the Federal Register in April 2023. It was then approved and became effective in August 2024. And the reason that we're all here today is because there are some upcoming mandatory compliance dates, but more on that in just a minute. If you'd like to follow along with us today, you can get a copy of this rule from the Federal Register. I'm going to ask our team to share a link to that in the webinar chat with you. The link will also be in the slides, which you will receive after the session. Before we get too far into the weeds, the first question I want to answer is, who does this rule even apply to? Well, that's not as straightforward as you might think. The rule applies to a specific subset of financial institutions that the rule calls covered institutions. And under that umbrella, we're going to find investment companies, both registered and unregistered. It also includes registered investment advisors, broker-dealers, funding portals, and transfer agents. So if that sounds like you, if one of those sounds like you are in the right place. And I will say, if that doesn't sound like you, if you work for a financial institution like a bank or a credit union that does not fit into one of those categories, then I want to say really early on, this rule does not apply to you, even if you are publicly traded or regulated by the SEC in some other way. That said, your federal regulator does have similar requirements, so you're welcome to stick around because we'll be covering some GLBA best practices. Generally speaking, though, if you work for a bank or a credit union, the legal specifics that we're talking about today would not apply to you. I am going to try to avoid reading large chunks of the legal text to you today, but I will make some quotes available on the slides for you to reference later. That said, another question we've been hearing is, when am I required to comply with these updates? Well, the SEC says that if you work for a large institution, compliance is required by December 3rd, 2025. And if you work for a small institution, compliance is required by June 3rd, 2026. And there are no exemptions here. This is very clearly by their design. Several places in the preamble, the SEC says things like small entities are just as vulnerable as large ones. So in short, this rule casts a wide net. It applies to the big firms with entire compliance departments and to the small offices where one person wears all the hats. If you're wondering whether you're a large institution or a small institution, the SEC has some guidance on that. They say that large investment companies have more than $1 billion in net assets at the end of the most recent fiscal year. Large registered investment advisors have more than 1.5 billion in assets under management, or AUM. Large broker dealers are defined as all non-small ones. So that's great. Negative definitions are always so much fun. But broker dealers are defined in another rule as less than 500,000 in total capital and not affiliated with a larger firm. And then transfer agents are defined also as not small. All are large unless you meet those small requirements. And I do see a couple questions coming through already. Yes, the slides will be provided after the webinar. So thank you so much. The last question I wanted to address is why? Why is this updated rule needed? Well, Regulation SP has been around for a while, since 2000 actually. There have been a couple minor updates over the years, but nothing major. So why now? Well, the rule preamble gives us a few reasons, and it really boils down to this. The first is that we are handling more customer data than ever before. Along with that, technology is rapidly advancing, so there are more threats to our systems and our data than ever before. And because of the efficiency of outsourcing, we are becoming more decentralized than ever before. The combination of these three things has really put the financial industry in an interesting place when it comes to protecting customer trust and financial stability. So if there is one takeaway I want you to have from this overview, it's this. The purpose of the updated rule is to help financial institutions better protect customer data and ensure customers are promptly informed of breaches. How exactly it does that is where we are going next. And just a quick reminder, I see several of you are submitting questions, but continue to submit those questions. We're going to chat with you and answer those. And I see a lot of questions about assets under management, AUM. So the rule doesn't actually give us a date that you need to calculate that by. The rule just says assets under management. So I don't know currently if that's current assets under management or assets under management as of the last date that you reported or what that might be. But stay tuned. I will check on that and let you know. So next up is the regulatory requirements. What does the rule require you to do? Let's find out. The updated rule requires several things, and here's how we're going to break it down today. The first is security policies and procedures, then incident response, customer notice, service providers, and then records retention and destruction. And we are going to start with the security policies and procedures. The rule requires you to develop, implement, and maintain written policies and procedures that address administrative, technical, and physical safeguards for the protection of customer information. It's a lot of words, but this is actually something that was required in previous versions of Regulation SP. The difference in the updates is that the definitions for things like covered institutions and customer information were expanded a bit, but otherwise, there's not a whole lot new here in this requirement. When we talk about security policies and procedures, there are a lot of different areas that this could include. The ones that I'm listing here on this slide are some common ones for financial institutions, and I'm not going to read this whole list to you, and I'm not saying that you need all of these to comply with the rule. This list would change based on the size and complexity of your organization. Just to shout out a few key items on this list though, the rule explicitly talks about things that need to be included in your data management, incident management, and vendor management policies. So those ones are basically going to be givens, and we will cover those topics in more detail later. Just to shout out a few others that have been trending this year in the financial sector. The first is artificial intelligence. So go ahead and mark that off your bingo card. You can't get through a day right now without hearing about AI or artificial intelligence, I feel like. AI is everywhere, and financial institutions are being asked more often for their official stances on it. So whether you're big or small, you need to have a policy that says if AI is allowed, and if so, what those AI tools are allowed to do for you. Another one that's been coming up more frequently this year is change management. So this one shows up a lot in exams of the financial institutions we work with. And this really applies to, I'll say, larger entities. But basically, we want to know, do you have a plan for making changes to your key systems securely? After that is IT asset management, and a big area of this right now that's being emphasized a lot is shadow IT. Do you know where your customer data lives, and are you sure about that? One thing that you'll hear me say a couple times today is you can't secure data if you don't know where it lives. And lastly, I'll say log management. This one has become kind of a big deal in light of recent incidents. Basically, are your systems logging what they need to, and can you use those logs if you need them? So those examples in mind, I'd love to ask you, does your organization have security policies and procedures? So I'm going to go ahead and launch a poll question here, and we'll see how people answer. Our answer options are kind of a scale. We've got yes, fully, comprehensive written policies and procedures, yes, mostly, yes, somewhat, no, not at all, and not applicable, or I don't know. I'll give you guys just a few more seconds here. And I'm going to close that and share those with you. And that is really encouraging to see. 91% have said yes fully or yes mostly. So I love to see that. Again, it's not really too surprising since this was a requirement in the previous versions of Regulation SP, but it's great to see there's a lot of confidence in the policies that you currently have. So that is awesome. If you are looking for assistance with writing your policies, though, I would love for you to check out this recent webinar by my colleague, Savannah Richardson. In July, she gave an absolute masterclass on how to write an AI policy. So it's a great resource about what needs to be included, whatever your official stance on AI may be. So you can see that recording now at tandem.app/webinars, and I will ask our team to drop a link into the chat for you. Also, Tandem does have a policies management software. The product comes with more than 40 fully customizable information security policy templates. So I'll be showing this product during the bonus content, so stay tuned. The key takeaway I want to leave with you here is this: clear security policies and procedures protect customer data, reducing the risk of harm. That word harm is actually used a lot in the rule, which we'll be getting into in just a little bit. The reason that I wanted to start with policies and procedures, though, is because the old saying is really true: an ounce of prevention is worth a pound of cure. Security policies and procedures are a great way to prevent incidents, and I'll say keep you from having to worry about the rest of the stuff we're going to cover today. So there's that. So what happens, though, when or if things go sideways? What do we do then? Well, that's where the incident response program kicks in. The regulation now requires you to have a written program that is reasonably designed to detect, respond to, and recover from an incident involving unauthorized access to or use of customer information. So in short, if someone breaks in and gets access to your stuff, how are you going to fix it? And I'm actually going to ask this poll question really early, but I'm curious to know if your organization already has an incident response plan. We've got the same skill that we showed you guys before, and I would love for you guys to chime in and let us know how that's going for you. Thank you so much. Someone in the comments just said, highly recommend the AI webinar. It was great. Thank you. We really appreciate that. I agree. Savannah did a great job. All right, I'm going to close that and share those results with you. And it looks like 2/3 of us say yes, fully. We have a comprehensive written plan. So that is really exciting to see. Hopefully this will just be some polishing up for you and some information that you can use to improve your plan. And for everyone else, I hope that what we share will be able to help you continue to build out those plans. So that's exciting. Moving on here. I'd like to spend a few minutes diving into some examples of what a good incident response plan should include. And we're going to start with that detect phase. What does it look like to detect an incident? So what I'd like to do is start with an acronym called PLAN. Your plan should include details about how you plan to detect an incident. And I was going to insert a Ted Lasso joke there, but I'm not going to. If you've seen Ted Lasso, you know, words starting to sound like a sound. So the first way you can detect incidents is through people. People can tell you if there's been an incident. Maybe a customer spotted something fishy, or maybe an employee clicked a link. And if you work for a team, everyone should be trained to some extent on identifying and reporting possible incidents. So if they're seeing pop-ups on their screen that they've never seen before, you know, they should be able to report that to your IT team. Another way to detect incidents is through logs. So in 2025, logging isn't just for lumberjacks, it's a key part of security. Make sure that you are tracking those operating system logs, service logs, application logs, user activity logs. You get the idea. A third way is through alerts, so notifications of suspicious activity from your systems, so things like your IDS, your SIM system, anti-malware, things like that. And then lastly is through the news, publicly available information. If you learned about an incident while you were scrolling on LinkedIn, that still counts. External information sources can be incredibly valuable in providing details to you about incidents and vulnerabilities. Often, incident detection takes on many flavors at the same time. It's kind of like Rocky Road ice cream, except not as fun. It's really what you do with the data that's going to be what's important. That's called analysis. You analyze these details to discover information about what happened, how did it happen, what was affected, and how do you know? As it relates to Reg SP, a key part of this process is answering the question, what was affected? Your plan is legally required to spell this process out for how you plan to identify what customer information systems and customer information were compromised in the incident. So if that's part of your plan, great job, that's awesome. And if it's not part of your plan right now, this is a good step one. When it comes to responding, Reg SP requires you to, quote, contain and control the incident. This should go without saying, but if you see a fire, try to put it out, right? How you respond to an incident, though, is going to vary by system and by impact. For example, Joe accidentally uploading a document with customer information in it to ChatGPT is very different than Sally clicked a phishing link and now we have ransomware, right? That said, in 2025, a lot of common response tactics include isolating affected areas, logically, physically, sometimes both, unplug it. It also includes disabling compromised accounts or functions. So if Jim's account got compromised, Jim should lose his privileges, literally. Temporarily, of course, but still literally. Then there's also blocking malicious traffic. So malicious IP addresses or traffic based on some kind of pattern that you've been able to observe. And then heightening your security awareness, because a lot of times attackers will use one incident to hide another. It's like a magic trick, right? You're watching what the magician's doing over here when the trick is actually happening right here. So depending on how the customer information or system got compromised, you're going to want to pick the options that work best for you. You'll want to pick a plan that lets you contain and control the incident in the best way possible. So an effective plan needs to allow for that wiggle room when you need it. And then recover. Just like with response, recovery is going to depend on your circumstance. Some common recovery strategies include restoring clean backups, repairing affected files, rebuilding compromised systems, remediating vulnerabilities, resetting authentication tokens, and replacing ineffective controls. So an incident response plan isn't about really laying out this 5-course meal for dinner. It's about keeping a stocked pantry, right? You may not know exactly what you're going to make, but you'll be ready to put the right ingredients together when you need them. If you're looking for some tools to help you build your incident response plan, I'd encourage you to check out the NIST cybersecurity framework, specifically those detect, respond, and recover functions. Those really speak to what we're talking about here today, and they even use the same terminology. If you want to take your plan to the next level with some specifics, check out NIST's special publication 800-61. It's their cybersecurity incident response guidance, and it really dives deeper into practical response techniques. Both of these documents have been extremely valuable to me and to my company, so I'd highly recommend downloading a copy and enjoying it with a nice cup of coffee on some beautiful fall afternoon. Those links will be in the slides for you to access later. If you're enjoying this session, I would love for you to join us for the next one. Our next webinar is scheduled for Tuesday, September 30th at 2 p.m. Central Time on the topic of what it looks like to implement the NIST CSF. So in this webinar, I'm going to have the opportunity to interview Daniel Elliott from the NIST Applied Cybersecurity Division. And we are going to dive deep into some topics related to the CSF, and we would love to have you join us. So if you're interested, you can use that link that we already shared and register now at tandem.app/webinars. On that note, Tandem also has a free product that allows you to complete cybersecurity assessments based on frameworks like the NIST CSF. So you can check it out on our website, and I'll be showing that to you later as well. The key takeaway that I really want you to have here is this: an incident response program provides a playbook for minimizing damage and safeguarding customer trust. And a quick note on this is that the size and complexity of your incident response plan should really match the size and complexity of your organization. If you work for a large firm, one of those 500 plus employees, or one of those officially defined as large according to the rule, you probably have a very big landscape to protect, right? Lots of people, lots of technology, lots of vendors. It makes sense that your program should be more comprehensive. On the other hand, I recently met with an investment advisor running a smaller shop, and his setup, we asked him about his technology environment, and it really boiled down to a few assets. He had a laptop, a cloud storage solution, an email account, and his investment software. So naturally, his incident response program would look much simpler. Whatever the size of your business, though, you still need a plan. The scope just needs to fit your environment. And going hand in hand with customer trust, let's spend some time talking about the customer notice requirements. And we are really getting to the heart of the new things now. If you experience an incident that compromises customer information, the Reg SP amendments now require you to notify those customers. Sounds simple enough, but just like when I get home from a road trip, there's a lot to unpack here. The first thing I want to unpack is this definition of sensitive customer information. The rule defines this, and I'm just going to read it to you, as any component of customer information alone or in conjunction with any other information, the compromise of which could create a reasonably likely risk of substantial harm or inconvenience to an individual identified with the information. That's a tough definition. And there are really two things that I'd like to note right here. First is that this definition includes a lot of definitions inside of definitions, inside of definitions, inside of definitions. You get the idea. For example, if you connect the dots far enough, this definition of customer information is defined in another rule as non-public personal information, is defined in another rule as personally identifiable financial information, which is defined in another rule as any information a consumer provides to you to obtain a financial product or service to you. So there is a lot of nesting going on here. The second thing I want to note is that this definition includes some really subjective language. For example, reasonably likely risk. Who decides what's reasonably likely? Is that you? Is that your customer? Is that the SEC? Is that some judge in a court down the line? Because if you've ever done a risk assessment, you know reasonably likely depends on a lot of factors. Now, I understand why the SEC wrote the definition this way. It's so that the definition can be evergreen. And that's, on one hand, a really good thing, right? It provides a lot of flexibility and wiggle room, and it means that they don't have to update the rule as often. On the other side of things, it's hard to comply with something that's not well defined. The rule gives us some examples of what this could look like, including identifiers that may be used to authenticate identity and account-related information. But be aware that this definition is pretty broad. It's much broader than many definitions of sensitive customer information out there, including those in state laws. So it'd be good for you to work with your legal teams and get your ducks in a row. The next thing I'd like to unpack is this definition of substantial harm or inconvenience. And I've got a quote here on the slides, and I've decided that I'm not actually going to read that whole quote to you, but here's the gist. The SEC has decided to not actually define what the phrase means either. And here's a fun fact for your next compliance trivia night, because I'm sure those are a thing. The phrase substantial harm or inconvenience actually comes from GLBA itself, which was passed by Congress over 20 years ago, and it wasn't defined there either. So really the SEC is just carrying on a long-standing tradition of the government saying words without explaining them and then leaving you to connect the dots. I understand that can be frustrating, especially if you're a smaller business without a compliance department to parse legal language all day long, but that's why we're having this webinar. So I hope one of the messages you hear is that you don't have to figure this out alone. If you're looking for a list of things that would probably constitute substantial harm or inconvenience, here are a few examples that are commonly understood to fit that bill. Theft or fraud, harassment or intimidation, physical harm, impersonation, damaged reputation, impaired credit eligibility, misuse of information to obtain financial products or services, and then unauthorized access to or transactions on customer accounts. So the last thing I want to unpack is that the rule gives two notable exceptions. The first is that you do not have to notify customers if you've done a reasonable investigation and you've determined that the data wasn't and isn't likely to be misused. You also do not have to notify customers if you can show that a specific individual's data wasn't accessed or misused at all. In one way, this makes sense, right? The SEC doesn't want you to over-notify customers. When you get pinged all the time, you stop paying attention and you end up with 500 red dots on your phone screen. But here's the tricky part. This means these exemptions, or exceptions, I guess we should call them, mean that there is no real end date on your responsibility to notify customers. For example, imagine data gets breached and it's encrypted today. You may not have to notify customers right now because that data is encrypted. But if 10 or 20 years down the line, that encryption is broken or a key is exposed, then you'd have to suddenly send notice. Trust me, nobody wants to be writing that letter that says, "Hi, remember that breach 25 years ago? Sorry about your money." So my encouragement would be to keep this exception in your back pocket if you need it, but I would be very careful and very intentional when using it. So that's a lot of words, a lot of ideas. We're going to take a bit of a brain break now, and I want to tell you a story. It's actually a true story. I have a friend who was caught up in one of those large data breaches a while back, and it was one of those we all knew about it the day it happened kind of breaches, but she didn't hear from the company until 9 months later when a breach notice letter arrived in her mailbox. The letter said a lot more than this, but my friend snapped a picture of just this section in the letter and sent it to me. It gave a few brief assurances like we're making our system stronger and we don't want this to happen again. And my friend texted this to me with the message, "Cool, thanks for nothing." Ouch, right? That story has stuck with me, especially in light of all of the incident notification rules that have been coming up in the last few years. But the reason that story sticks with me is really because of two things. First, in the context of this rule, timing matters. 9 months is a long time, and it can come across to customers as too late to make any kind of meaningful difference. And the second is that tone matters. Short assurances like, "We don't want this to happen again," don't really help customers understand their risk or what they should do next. And the reason that I share this story is because when we talk about customer notice, it can be easy to forget that there's a person behind the customer. We are all customers in some way, and we want to be cared for by the companies that we trust our data with. And I think that's a big reason why the SEC is kind of going hard in the paint here. And I really share this with you to tee up the next point, which is timing. The rule says that notice needs to be provided as soon as practicable, but not later than 30 days after becoming aware that unauthorized access to or use of customer information has occurred. Yes, practicable is apparently a real word, and a 30-day max is not very long at all. The rule says you may still be working towards remediating the breach when notice needs to happen. Now, as far as exemptions or exceptions to this, there is only one that the rule gives, and the notice may only be delayed if the United States Attorney General asks the SEC for one in the name of, quote, national security and public safety. So, notify soon. Moving on to format, this is pretty standard, but notice must also be provided in writing. The in writing part can mean either physical or electronic, as long as the customer has agreed to receive information electronically and it meets the SEC's guidance on electronic delivery of documents. At a minimum, the notice will need to include things like general information about the incident and what information was compromised, the actual dates of the incident or an estimation of when it occurred, your institution's contact information, including a phone number, email address, or online contact form, postal mailing address, and the name of a specific office that customers can contact for assistance. And then guidance for the affected individuals. This guidance should provide how-to details on things like how to review account statements, how to report suspicious activity, how to place a fraud alert, things like that. Truth be told, I would encourage you to work with your legal teams if and when you are crafting a customer notice. But as you are looking for a place to get started, the FTC has a helpful guide for businesses on responding to a data breach. So a link to this resource will be in the slides. Tandem does also have a few things around this topic, so stick around for our bonus content and I'll be showing you Tandem Incident Management. This is honestly one of those hope you'll never need it kind of things, but if you do experience an incident, timely and thorough notice gives customers the information that they need to respond and protect themselves after a breach. Also, Just a little soapbox here. Security controls and preventive controls matter. Turn on multi-factor authentication on your systems, freeze your credit, set up fraud alerts, and even if you know to do these things, your customers, your friends, your loved ones, they may not. So I'd encourage you to help them do these things too. My grandma's Facebook account password recently got compromised, so I helped her change it. And while I was doing that, I turned on multi-factor authentication for her. It took all of 3 minutes, and these things don't take a long time to do, but they can save a lot of headache. I share this with you because if we take care of our security, if we follow our policies and procedures, then having to spend our valuable and limited resources on customer notices is much less likely. All right, we are getting close. Hope everyone is still with me here. The next to last topic we're going to cover today is service providers. The Reg SP amendments require you to have written policies and procedures reasonably designed to require oversight, including through due diligence on and monitoring of service providers. So in the financial sector, we tend to call this a vendor management program, a third-party risk management program, things like that. And before we get into what all of this means, just to get a vibes check here, does your organization have a program for managing vendors? I'm going to go ahead and launch that poll for you. We've got the same scale that we had before. Yes, fully. We have a comprehensive program. Yes, mostly. We have an informal program. Yes, somewhat. No, not at all, or not applicable / I don't know. And I'll give you just a few more seconds to respond here. I'll close that and share those results. And it looks very similar to what we were seeing with the policies and with the incident response. So lots of people have a fully comprehensive written program, which is great. And if you don't have a comprehensive program, that's okay. No time like the present that we can start working on one. So the first thing that I want to do is define what the rule means by service providers. As with the other areas in this rule, the rule really paints this definition with a broad brush. It says a service provider is any person or entity that receives, maintains, processes, or otherwise is permitted access to customer information through its provision of services directly to a covered institution. In short, if someone has your customer data, they are considered a service provider under this rule. Now, there are 2 specific incident response requirements in the rule related to service providers. One is that your service providers must protect against unauthorized access to or use of customer information. It's the vendor management golden rule, right? Your vendors should treat your customers the way you would want your customers to be treated. This means that they should have their own security policies and procedures, their own incident response programs, and things like that. It also says that service providers must notify you as soon as possible, but no later than 72 hours after becoming aware of a security breach. Now, this one's a little bit tricky, and the reason that it's tricky is because the SEC does not directly regulate your vendors, but it can now hold you accountable for your vendors' actions or lack thereof. In practice, this kind of creates this weird game of compliance telephone where you're responsible for enforcing the rule through your contracts and oversight. While the SEC does not require you to bake this into a legal agreement, it's a smart risk management idea to try. So a question that's come up quite a bit is, if a service provider experiences an incident and it breaches my customer's data, can they just notify the affected individuals for me? Cut out the middleman, as it were. The rule says that yes, but only if you agree to it in writing and you maintain a record of the contract. And even then, you are still liable for ensuring the notice is provided. So what does this look like practically? How can you do this if you currently have a program, or even if you don't? What are the places that you would do to get started? So the first thing that I would encourage you to do is make a list of your data critical vendors. I said it earlier, but it is so important. You can't protect your data if you don't know where it lives. So we have to start with this process of determining which service providers actually even have access to customer information. Once that's done for those vendors, make sure that your agreement or contract has a security clause in it. Your vendor needs to be legally required to protect your data and your customers' data. In that same thread, make sure the agreement requires the vendor to notify you of incidents as soon as possible. At Tandem, we spell both of these things out very clearly in our agreement. Literally, if you search for the word security program or notify, you're going to find these almost instantly. We know it's important to financial institutions, and so as a service provider in the financial sector space, it's important to us too. That said, if you're in a relationship with a vendor and your contracts do not spell these things out, ask for an addendum. I just merged those two words there. Ask for an amendment or an addendum. It is not unreasonable to expect these things of your vendors. And contrary to what vendors might want you to think, your contract can be changed. And now you have a compliance mandate to back up your case. If your vendors say no, it might be good to think about what that means and if you should be trusting them with your customer data. Lastly, ask your vendors for proof of security testing on the regular, something that verifies that they are doing what they say they're doing. This could include things like SOC reports or letters of attestation that they've had other forms of testing, like pen tests or vulnerability assessments. If your vendor is going to have a security program, then an independent party needs to validate it. If this is your first rodeo, or even if it isn't, I would love for you to get a copy of Tandem's Vendor Management Workbook. I personally poured a lot of love into this resource last year, and it's a document that goes over the basics of what does it mean to manage your service providers effectively. It provides examples, recommendations, guidance, best practices, and even some fillable forms that you can use when reviewing your vendors. There's even a form in there that teaches you how to review a SOC report. So check it out. I'll ask our team to drop a link to that into the chat for you today. The workbook is a great complement to Tandem's vendor management product, so be sure to stick around for our bonus content in just a few minutes. And the key takeaway that I think the SEC wants you to have from these updates is that outsourcing shifts control, but not accountability. Because of that, third-party oversight is key to protecting customer data. TLDR is that your customers are your responsibility, even if vendors are involved. Yeah, that's a great question, Chantal. Chantal asked, is the vendor simply having an incident notification program sufficient, or does it need to specify 72 hours? We have had pushback from major vendors in the financial space. I think that's kind of expected right now. Having an incident notification requirement in those contracts is really important baseline. If you can get it to be that 72 hours, if they have access to your customer data, that's really what you want to do because that is the legal requirement that's going to be expected of you now. So if there's a breach and your vendor has customer data compromised and it comes out 6 months down the line, that's going to be a little bit of a problem and difficult to explain. So I think the best thing to do would be to note those risks. So if you have an incident notification requirement, but it doesn't say 72 hours, determine if that's acceptable or not. Is that within your risk tolerance? And document. So if it's not within your risk tolerance, then you as the customer of the vendor have the right to go somewhere else. Start looking for other vendors who may be able to meet those requirements for you. Or something that we've seen in the banking industry specifically is negotiate with your peers, negotiate with other investment advisors in the space or other financial institutions. There's a lot of different options. So I would say explore what those options are and document. I hope that helps. The last topic I want to get into today is the records retention and destruction requirements. And before we do that, and I kind of have a feeling on how this one's going to go, so I'm tempted to not launch it, but I'm going to anyways. Does your organization have a formal data retention and destruction policy? So our answer options are the same as before, so I will give you all a few seconds here to respond. Alrighty. And really good news, we've got about 70% that say yes, or 67%, and then 15% say yes mostly, and then on down from there. So very good. Glad to see lots of people are having this policy in place. And again, if you don't, we'll go over what those requirements are going to expect of you. Truth be told, though, we're not going to spend a ton of time here today because the short and sweet of it is that you need to prove your compliance over time. And those times vary based on covered institution type. So investment companies need to retain all records for 6 years. The policies and procedures need to be easily accessible for that full time, and then all other records just for the first 2 years. Investment advisors need to keep all records for 5 years, and they need to be easily accessible for 2. And then broker dealers and transfer agents need to keep all records available and easily accessible for 3 years. Why these timeframes are all different, I really can't say, but find your row on the slide and then make sure to save your documents for that time frame. And then lastly, it's really straightforward. It should go without saying, but properly dispose of customer information. If it's physical, shred it, destroy it, make sure it can't be reproduced. And if it's electronic, actually destroy it. Don't just delete it or wipe it or presume your vendors are going to take care of it. There was actually a big case a few years ago where a financial institution hired a vendor to decommission a bunch of old hard drives. The company found out that things hadn't gone according to plan when a kind consultant in Oklahoma reported to the financial institution that the hard drives he'd purchased online from the decommissioning vendor still had customer data on them. It became this whole big investigation, fines galore, and the moral of the story is don't be that guy, right? Hold your vendors accountable, dot your I's, cross your T's when it comes to secure destructions. So the moral of the story is this: retention shows your work when you need it, and secure destruction helps keep data out of the wrong hands. So that is the Reg SP amendments in a nutshell. I hope you all feel more informed than when you first got here. So we are going to go ahead and move now into our wrap up and bonus content. For further reading, I'll be including a slide with links to everything that I've shared with you all today. And just a reminder, you will get a copy of the slides via email after the session. It typically takes us about 1 to 2 business days to get those over to you, so keep an eye out on your email inbox. And when you leave the session, please fill out the survey. At Tandem, we value survey feedback really a lot, so much so that we are giving away a $50 Amazon gift card or one of 3 nifty hats. If you win, you can pick which color you want. Personally, I think the navy blue one is clean, but don't take my word for it. Don't take style advice from me either. I also asked why the word was upside down and backwards. Turns out it's what the kids are wearing these days. So if you want to look super trendy, fill out our survey and let us know how you like the session. As I've mentioned a few times today, Tandem is an information security and compliance software suite designed specifically to help organizations like yours be secure and be GLBA compliant. So if you are a current Tandem subscriber, thank you so, so much. We are truly grateful for you. You are the reason that we get to provide free consulting webinars like this one. And if you're not a current Tandem subscriber, we are so glad you're here and we'd love to show you what Tandem can do. So I'm going to jump in now. This is what we're calling bonus content. I'm going to go ahead and switch on over to Tandem and show you how you can comply with these requirements using the Tandem software. So Tandem is a web-based application. You can access the software online through any modern web browser, and we have our suite of products here. I'm going to start with our information security policies product. As I mentioned, our information security policies has about 40 information security policy templates. And those templates are really great because they're not just boilerplate. They're not just going to be spit it out and then you can customize it however you want, even though you totally can. With this product, we have a questionnaire built in that has about 100 questions which you can answer. They're going to be multiple choice questions that you can answer, and then the policies are going to be generated for you based on your organization. So here you can see a full list of our proposed policies, including a bunch of the ones that I shared with you earlier and then some. And when we make updates to our policies, you get notified about that. You will be alerted here on this page and through our software updates blog. And when we make updates to the software, you can see those. It's going to have it highlighted in green or red what we've added or removed to those. Now, something I do want to mention on these policies is that Tandem has a great version control history. So here, if you click the version history button, you can see any time the policy has been updated previously. So you can track every single version of your policy as long as you're a Tandem customer. So this is really great for compliance purposes. If you need to go back to one in March when we first added this policy, you can go and see what the policy looked like at that time. So you can track those policy changes as they happen, which again is really great for comparison. And then we have a lot of download documents where you can export those. You can create custom documents, and you can even create comparison documents to redline what's changed over time. So that is the policies product. I'm going to switch now and go over to incident management. Incident management is actually one of our newer products. It came out just a couple years ago, and it helps organizations build a incident response plan and then track those incidents as they happen. A couple things that I really want to point out here for you, though, is that our incident response plan is going to be tailored based on your organization type. So if you are regulated by the SEC, you're going to see suggested wording based on your regulator. Some cool things about the incident response plan include things like your incident handling process. You can assign severity ratings to your incidents, and then you can create specific action plans, which are basically checklists that you can follow in the event of an incident. One thing that I do want to mention here is that there are communication templates. So here we've got customer communication and internal communication templates. So you can use those to really kind of help you communicate in the event of an incident. So they are starting places. They are not final. You're going to want to change those based on what actually happened at your organization. But those are available for you as part of the product. Now, something that's really cool is that you can track your incidents when they occur. So here we've got one based on the Move It breach that happened last year. This one affected a lot of people. And so you can see exactly how we detected, how we responded to, and how we recovered from this incident, and then improved our plan based on lessons learned. Each of these is going to have our series of checklists, or our checklist series of steps, I should say, based on what we did and how we responded. So this is all going to be directly from your plan that you created. And again, we've got a lot of templates to help you get started with that. One neat feature about incident management is that we do have a peer analysis component here. So you can actually compare your incidents with your peers. You can see things like average time to report. How long does it take your organization versus how long does it take other organizations using the Tandem product? Our peer analysis is completely optional, completely anonymous, but it is really cool to provide some metrics and be able to see how we measure up with our peers. Moving on to vendor management now, this is that service provider management piece. And with vendor management, you can create records for your third-party service providers. You can perform risk assessments on those vendors. Then you can upload your contracts and documents and even perform reviews on them. So Tandem does provide a lot of review templates, which you can use to help you know what are even some things that I should be looking at? What might I need to check on and see, does my contract say what it needs to according to regulatory guidance? So there are a ton of great resources in this product, and it's a really streamlined way to manage and monitor your vendors on an ongoing basis. Every single one of our products does have download documents, so you can export the information about your vendors either individually or on a broad scale. So if we wanted to see a report of, we'll say all of our vendor contracts that we haven't reviewed yet, all of the ones that we're not sure about if they have the customer notification requirements or not, you can get easy reporting based on that here in the product. And then the last product I want to show you is cybersecurity assessment. We just released the updated version of this product just a few months ago. And what this product allows you to do is perform a cybersecurity control self-assessment. So let's say you want to go through the NIST cybersecurity framework and see, do we have controls in place that help us achieve these detect, respond, and recover goals from NIST? So here in our NIST CSF assessment, we can edit our assessment here and go through each statement. And for each statement in the CSF, we can say what our current status is and what our target status is. We can explain where we're at. If you have the pro version, you can assign responsibility and attachments. And then my personal favorite feature is this mapping. Tandem has these frameworks mapped to each other. So if you use multiple frameworks, like maybe you've done the FFIEC CAT, or you use the CISA CPGs, or you do the CIS controls, whatever the case may be, you can see how these control frameworks map to one another. So that is a really powerful tool when you're doing self-assessments. We do also have peer analysis here as well. So one of the cool things about peer analysis is you can see the comparison based on framework by frameworks. You can also see it on a category by category level, and you can even really get into the weeds and see peer comparisons on a control by control level. So this is a really neat way to be able to, again, benchmark yourself, see how you compare with your peers, see how you align with other organizations using that product. So peer analysis is a great feature and a great way to be able to, again, show your work, as it were. So that is the Tandem cybersecurity product and the Tandem suite. I'm going to actually stop there for today. We've got a whole bunch of products and we'd love to show you a whole lot more about those. But for now, since we're getting close to time, I am going to go back over to the slides. A few additional things that I do want to share with you about Tandem. We make content and functionality updates to the software every 2 to 3 weeks as part of our development sprints. We also educate our users about those updates with our software updates blog, knowledge-based articles, and training video library. When you have questions, you can reach out to our dedicated support team of Tandem software experts. So if you need additional assistance building your program, you can also work with one of our partners. We also have an annual conference designed for users of the Tandem software. We just announced next year's event, and I literally can't wait. I share all of this with you because with Tandem, you don't just get access to another software product, you get access to a team and a community of information security professionals. If you'd like to learn more about Tandem, you can sign up to watch a demo on our website. Those are going to be a much deeper dive than what I gave you today. You can also fill out the end of session survey to request additional information, or you can sign up for free to get started. You can sign up on the survey or on our website at tandem.app/cybersecurity. And with that, I think we will just about call it a day. Thank you all so much for joining us. I hope this session has been helpful for you, and I hope to see you around. I am going to take a quick minute here and take a look at some of the questions coming through. So since we have a couple minutes left, if you have questions, now is your chance to get those in. I will try to answer a few of those with the time that we've got left. Stephen asked, does your vendor module include sending questionnaires to vendors? If so, does your firm review the data provided and produce a report of the results? So yes, so I'm going to switch back over actually and show that to you. In vendor management, that's always the trouble with doing like a 3-minute demo. You don't get to show all of the features, but here in the product, we have a requests functionality where you can send questionnaires to your vendors and ask them to respond. And so they can respond by providing answers, they can upload documentation. So all of that is possible in the product. As far as reviewing the data provided and producing a report, the Tandem software does produce the results for you. Any additional review of that data, though, would be through one of our partners. So if you want to partner with a VISO or one of our consultants, you would be able to work with them to review that. So I would say that's Tandem plus a service, if that makes sense. So that's a great question, and we appreciate you asking. All right. Thank you so much for the feedback. I really appreciate all the comments. For a traditional retail RIA that recommends clients use a particular custodian, are those custodian service providers to the RIA and therefore required to give the RIA the 72-hour notice? I would say if they have access to your customer data, then yes, they would be subject to this. So given that you're asking about custodians, then yes, I would say that they would be part of this 72-hour notice. So great question. Thank you for asking. All right, and I think that is just about it. If we didn't get to your question, we will follow up with you after the session, so we hope to see you around. And thank you so much for being here. This has been a lot of fun for me, and I hope it's been fun for you as well. So we will see you guys next time. Have a blessed day.